Welcome to Case Flash, brought to you by the CBA Family Law Section. I'm Sam Schoonmaker. The Case Flash today deals with attorney's fee awards and the Supreme Court's decision in Berzins v. Berzins. The basic facts in Berzins are complex, but mostly irrelevant to understanding the decision. The administrator for a deceased divorce litigant filed multiple post-judgment motions. The trial court expressly found that the administrator's motions were duplicative, frivolous, and without basis in the law. The trial court awarded counsel fees based on egregious litigation misconduct. The administrator appealed. The appellate court affirmed the trial court under Ramin v. Ramin. The Supreme Court took the case and reversed for two reasons. First, the general rule is that parties pay for their own litigation expenses, and there are exceptions to this rule, including under Ramin. However, the Ramin rule is limited to discovery misconduct. In this case, the misconduct was unrelated to discovery. Second, the trial court did not act within its inherent powers when it rendered this fee award. The court could have entered an order under Maris v. McGrath, but that requires findings both that the defendant's claims were entirely without merit and that the litigant had acted in bad faith. Those findings were not made in the Berzins case. The Supreme Court reversed and remanded for further proceedings. Attorney Palmer, why did the counsel fee award under Ramin fail in this case?
The counsel fees claim failed under Ramin because Ramin is a very narrow decision, and in the Berzins case, the parties simply didn't prove egregious litigation misconduct as that term is defined under Ramin. In Ramin, the court itself recognizes the particular unique circumstances of the case, and in the Supreme Court's decision in Duarte versus Commissioner Correction, which came down in January, the Supreme Court goes out of its way to state that a general rule about attorney's fees was not created by Ramin. Apparently, they saw a need to reemphasize that in Berzins, but the big distinction in Berzins versus Ramin is that Ramin dealt with egregious discovery misconduct for failure to comply with 5 contempt citations on discovery, whereas Berzins was simply a case which didn't involve discovery but involved post-judgment motion practice.
You know, I think the other thing that's interesting in the discussion in Berzins is the underscoring of the particular relationship, the almost fiduciary relationship between husband and wife that was the underpinning of the discovery misconduct in Ramin, because that really helps limit Ramin to its facts and its egregious pattern of conduct. And I think that Justice McLaughlin spends a fair amount of time trying to show historically why Ramin was decided the way it was and why it should be limited. And I think that relationship between husband and wife in terms of disclosure was really important to him.
And I think the court discusses that in some length in Duarte as well,
right,
where it distinguishes Duarte, which was a discovery case, from Ramin based on the heightened duty between spouses, almost a fiduciary responsibility.
Would you agree, though, that there was some broad language in the Ramin decision? The Ramin decision could have been read to include conduct beyond discovery. The Ramin decision talked about the conduct actually occurring in the courtroom. The reading of a magazine by a witness, instead of paying attention to the trial, just disrespectful conduct before the court. Do you think that the Berzins case is pulling back from Ramin?
No, I think what Berzins is doing is it's telling us that if we're seeking attorney's fees under a Ramin standard, that we have to do our due diligence, that we have to go to court and get orders, that when the orders are violated, we have to pursue motions for contempt, and we can't leave it to the court to do that. The subsequent decision of Gong versus Wong, in that case, the parties attempted to get Ramin damages for discovery violations, but in the Gong case, the parties never pursued their discovery motions. They filed them and just left them there. So in that case, they said no to Ramin damages. So I think what it's forcing us to do as lawyers is it's forcing us to go forward with these motions. I take a very limited view of Ramin, because what I view Ramin as is a case where a litigant came to court and the court said, we're not going to hear you, we're going to mark your motion off. And all Ramin did was extend the Onaman case to say, you have to have a hearing. If there's an artfully drafted motion that the court can grant relief on, the court has to hear the motion, which it didn't do in Ramin.
Yeah, I'm not sure that I disagree with anything that Alan just said, except that I think we all know in practice everybody read Ramin more broadly than the court is clearly telling us now was correct. And so there was room in there in that language. I think it was written much more expansively, and I think the whole point of this case is to say, whoa, we didn't mean it to be pushed to the degree that people might be thinking.
Well, Judge Gordon, what is egregious litigation misconduct?
Well, that's a good question. I'm not sure that we know much except what the cases now tell us. And we know that repeated refusal to comply with discovery orders and to meet that fiduciary relationship inside a husband and wife relationship can give rise to a Ramin type situation. And now we know that given Maris versus McGrath, which is cited in this case, that bald-faced lying can be construed as something which will give rise to an award of attorney's fees as a sanction.
Why did the claim under Maris v. McGrath fail in this case?
Well, the claim under in Maris versus McGrath, which was not a family case, it was one of those cases where you had people who'd been in a relationship and intertwined their finances, but not a marriage. The court basically said that the position of the plaintiff in bringing that action, the testimony that he gave, was just out and out untrue. It was more than a he said, she said kind of situation. All of the evidence lined up with her defense, and there was nothing to purport what he was saying except the fact that he just said, that's what I say. And because he was the plaintiff as well, I think they said the entire litigation was conducted in bad faith, and they said it specifically and repeatedly in the underlying decision. And Judge Schluger in Berzins, I think, did a great job of setting forth all of the misbehavior, let's call it that, the misbehavior that he saw. That was the filing of unneeded and unnecessary motions and actions and requests for rehearing without what he called even a colorable claim of the legal claim to do so. But he never made any finding that there was something done in bad faith. And that's what was missing, and that's what Justice McLaughlin says is necessary for the court to act under its inherent power. Lack of colorable claim plus bad faith. And that was found in Maris. Both of those aspects were found in Maris.
Attorney Parliament, do you think that the Berzins case marks the end of attorneys going to court and asking for effectively our fee awards based on egregious litigation misconduct, or do you see some evolution in the way that the attorneys might present their claims?
I think attorneys and litigants are going to be at a fork in the road, and that if it's discovery violations and if they've done their due diligence under Ramin and have their orders, I think they're going to go the Ramin route. I think for all other cases, which is probably the larger majority of cases in family, I believe that we're going to see, or we have the potential to see, increased hearings under Maris versus McGrath, because now we're going to have hearings on whether or not a party instituted a colorable claim in bad faith in order to get the attorney's fees. The one thing about divorce lawyers is we're not shy about going to court and fighting about our fees. And this just gives us some roadmap from the Supreme Court for simply another theory to test that.
When an attorney does go to court, though, and seeks fees under Maris, they do have a heightened burden that they have to meet, and that they show clear evidence. And the Supreme Court indicates in the Berzins decision that a trial court decision that isn't supported by clear evidence is going to be vulnerable on appeal.
Well, I think it's interesting. I think Berzins is important for a couple of reasons. Number one, it straightened everybody out about what Ramin actually may have meant, or does mean now, and what it's limited to. But it opens, I think, and sheds a light and kind of focuses a spotlight on Maris, which nobody had paid any attention to. And I'm thinking, what are creative lawyers going to do with Maris? Because basically what they've said with Maris is that pretty much, just like a lawyer needs a good faith basis to interpose a defense or a good faith basis for an objection or all those types of things under the canon of ethics, do clients now need a good faith basis to assert a claim or raise a defense? And if you don't have something in your arsenal of proof, are you acting in bad faith? Is it just because you said so and it's not provable and therefore seems untrue? That could be a real cautionary tale to any number of people in the way that they expect their attorneys to conduct litigation for them, I think.
I think also that we touched a little bit on the burden of proof. Ramin also deals with the burden of proof on those types of damages. And in Ramin, there's actually a burden shifting. If you've done your discovery, if you've done your due diligence and gotten your contempt orders, then the burden is on the other party to show that the information that they didn't produce was not harmless, which I think is a very difficult standard to meet. In Maris, under the burden of proof scenario in Maris, the burden of proof is on the proponent seeking attorney's fees to prove by clear evidence that the action was brought in bad faith. So I think that's a huge difference between the two theories right now.
Judge Gordon, why do you think the Berzins decision is important?
This is an interesting and fascinating area because people do spend a fair amount of time both rattling their swords, and I don't mean that really disparagingly, but talking to each other, counsel, talking to each other, and filing motions in court because they think the other side isn't playing fair in one way or another. And I think that we now have a roadmap in terms of what these claims mean and what you have to show.
Members of the family bar are going to become very familiar with Berzins because they're going to be seeing it a lot in the trial court. Thank you for watching Case Flash.